FAQ number 1, the most frequently asked question. What is driving under the influence or DUI? Driving under the influence is legally defined as driving while impaired by drugs and/or alcohol, and/or driving with a blood alcohol concentration of 0.08% or higher. And let's be clear about one thing, the ability to drive safely is severely hampered at that level, no matter how much you think you are used to it or can hold your liquor. Frequently asked question number 2. What is the 10-day rule? After a person has been placed under arrest for driving under the influence, they will receive a temporary driver's permit that will allow them to drive for 30 days. From the date of the person's arrest, they have 10 days to schedule a DMV hearing to contest the suspension of their driver's license. If the person does not schedule a DMV hearing, their driving privileges will remain suspended after the temporary permit expires. FAQ number 3. What are standardized field sobriety tests? Well, I'm sure you've heard of a breathalyzer, but field sobriety tests, or FSTs, are another good way to gauge impairment and possible intoxication. FSTs are physical agility tests that are used by law enforcement to determine if a person is impaired by drugs and/or alcohol. If a person is believed to have been driving while under the influence, law enforcement may request that a person perform a series of field sobriety tests before deciding to make a DUI arrest. FAQ number 4. What is blood alcohol concentration, or BAC? Blood alcohol concentration just simply refers to the amount of ethyl alcohol that is present in a person's bloodstream. A person's blood alcohol concentration can be determined through the administration of a breath, blood, or urine test. So that leads to FAQ number 5. What happens if a person's BAC is 0.08 or higher? If a person's blood alcohol concentration is 0.08 or higher, their driver's license will be confiscated by law enforcement, and they will be given a temporary driver's permit. This permit, as we mentioned before, will allow the person to drive for up to 30 days. But after the 30-day period, the person's driving privileges will be automatically suspended if no hearing is requested. FAQ 6. What are Miranda rights? You've all seen it in movies and TV. You have the right to remain silent, right? But it's a real thing, and it's very important. Once a person is placed under arrest, they must be read their Miranda rights by law enforcement. Miranda rights inform a person of their right to remain silent, their right to an attorney, and the right to have an attorney appointed to them. FAQ 7. What are the legal penalties for DUI? The penalties for DUI convictions vary and will depend upon several factors. If a person is convicted of a DUI, they may be sentenced with jail time, monetary fines, DUI school, community service, probation, driver's license suspension, and installation of an ignition interlock device. It can be very serious. FAQ 8. Should I accept a plea bargain for my DUI? There are times when a driver facing drunk driving charges will be offered a plea bargain by the prosecuting attorney. Essentially, a plea bargain involves the defendant pleading guilty to a lesser charge in order to keep the case out of the courtroom. It may save time and tax dollars to avoid a trial, but there are situations where a plea bargain is truly not in the defendant's best interests. The important thing to remember with DUI plea bargains is that you'll have a conviction on your criminal record. Perhaps this will be for a lesser offense than what you were originally charged with, but a criminal record of any kind may negatively impact you in many ways. And finally, frequently asked question number 9, why hire a DUI attorney? If you have been charged with a DUI, it is important that you hire a skilled attorney. A DUI attorney has the training, knowledge, and experience it takes to successfully contest your DUI charges. By hiring a DUI defense lawyer, you ensure that your rights and best interests will remain protected throughout the criminal case process. It's a complex system. We don't think anyone should try to navigate it alone. The law offices of Virginia L. Landry has been representing clients charged with DUI in Orange County and surrounding counties since 1959. At the law offices of Virginia L. Landry, clients receive the thoughtful legal counsel and aggressive defense they need to contest their DUI charges. For more information and to request a free consultation about your DUI case, please reach out using the handy contact form on our website, DUIQueen.com, or call 949-585-7400.